Indeed, even the prosecutors, who surely cannot be accused of being reluctant to find presidential misconduct, contended not that the president had lied about the nature of his relationship, but only about the details. Yet the managers, in their eagerness to find misconduct where none had found it before, have searched every nook and cranny of the grand jury transcript and sent forward to you a shopping list of alleged misstatements, obviously in the hope that among them you will find one with which you disagree. But they hope in vain. The record simply will not support a finding that the president perjured himself before the grand jury. Now, much of the questioning by the prosecutors and much of the grand jury testimony about which the House now complains so vociferously dealt with the president's efforts to explain why his answers in the Jones deposition, certainly not pretty, were in his mind truthful, albeit narrowly and artfully constructed. We are not here to talk to you today about the president's testimony in the Jones deposition. We do seek to convince you that before the grand jury, the president was open, candid, truthful. Now, the managers begin by asking you to look at the prepared statement that the president offered at the very beginning of his grand jury appearance. Before the president actually began his testimony, his lawyer, Mr. Kendall, spoke to Mr. Starr and told him that at the first moment at which there was an inquiry concerning the detailed nature of the relationship with Ms. Lewinsky, he wished to make a prepared statement, and he was permitted to do so. That statement acknowledged the existence of an intimate relationship, but it did not discuss the specific physical details in what I think we will all understand to have been an effort to preserve the dignity of the office. Now, the House has charged that this statement was somehow a, quote, premeditated effort to thwart the OIC's investigation. That is arrant nonsense. Even the independent counsel saw no such dark motive in this statement. Now, first, the managers advanced the baseless charge that the president intentionally placed the beginning of his relationship with Ms. Lewinsky in 1996 rather than 1995, as she has testified. Interestingly, they don't even purport to offer any support for this charge other than Ms. Lewinsky's testimony, and they offer not even the somewhat odd explanation originally offered by the independent counsel to explain why the president, having admitted the very worst things a father and a husband can conceive of admitting, would have shifted the time by 3 months. Next, the managers assert that the president's admission that he engaged in wrongful conduct, quote, on certain occasions, unquote, was false because the president actually engaged in such conduct some 11 times. And they assert as well that when the president admitted he had occasional telephone conversations that included inappropriate discussions, that was false because they had actually had 17 such phone conversations. Now, the president gave his best recollection of the frequency of those contacts. Ms. Lewinsky gave hers. Assuming that the majority is correct in its assumption that there were 11 or 17, can anyone imagine a trial in this court or in any other court in which the issue of whether certain occasions by definition could not mean 17 and occasionally could not refer to 11 would be the issue being litigated? Even the independent counsel, again, who could, of course, have pressed the president for specific numbers had they thought it important, did not take issue with this testimony. So thus, the perjury charge in Article 1 again comes down to the same allegations contained in the independent counsel's referral, that the president lied to the grand jury about two things: his personal subjective understanding of the definition used in the Jones deposition, and Second, he lied when he denied that he engaged in certain details of inappropriate conduct. Now, to conclude that the President lied to the grand jury about his relationship with Ms. Lewinsky, you must determine, that he touched certain parts of her body, but for proof you have only her oath against his oath. Those among you who have been prosecutors or criminal defense lawyers know that perjury prosecutions, as rare as they are, would never be pursued on the evidence available here. And those among you who do not bring that special experience at least bring your common sense and are equally able to assess the weakness of a case that would rest on such a foundation. Common sense also is enough to tell you that there cannot be any basis for charging a witness with perjury on the ground that you disbelieve his testimony about his own subjective belief in a definition of a term used in a civil deposition. Not only is there no evidence to support such a charge here, it is difficult to contemplate what evidence the managers might hope to rely on to meet that burden. Now, it's worth noting that Mr. Bennett, at the time of the deposition, pressed the Jones lawyers to ask the President specific questions about his conduct, rather than rely on this confusing definition that they proffered. In fact, when the President was asked in the grand jury whether he would have answered those questions, he said, of course, if the judge had ruled them appropriate, he would have answered truthfully. But the Jones lawyers persisted in their somewhat strange course. Strange unless one asks whether, armed with Ms. Tripp's intelligence, they purposely sought in some fashion to present the independent counsel a record that would permit just the sort of dark interpretation both he and the managers have proffered. I point you to one thing if you seek evidence that the President took the definition he was given seriously, and they responded carefully to the questions put to him, even if they required the most embarrassing answers. One need only look to the painful admission that he did have relations with another woman, and he testified to the grand jury the definition required that he make that admission. Here's what he said to the grand jurors. I read this carefully, and I thought about it, and I thought about what contact meant, and I thought about other phrases, my interpolation. And I had to admit, under this definition, that I'd actually had relations with Jennifer Flowers. Now, undeterred in its search for some ground on which to base the charge that the President lied to the grand jury, Article 1 abandons even the modest level of specificity found in the independent counsel's referral and advances the claim, quote, the President gave perjurious, false, and misleading testimony regarding prior statements of the same nature he made in his deposition. There can be no stronger evidence of the constitutional deficiency of this article than this strangely amorphous charge. And it's a deficiency that becomes even more obvious when you finally stumble across the theory on which the managers rely. To the extent one can determine what the Judiciary Committee had in mind when it drafted this clause, it appears that they intended to charge the President with perjury before the grand jury because he testified that he believed that he had, in his words, quote, worked through the minefield of the Jones deposition without violating the law, and that they hoped to support that charge by reference to various allegedly false statements in his deposition as charged in Article 2. Unhappily for the managers, however, the House rejected Article 2, and it is not before you in any form. Moreover, there is not a single suggestion in the committee debate, or more importantly in the House debate, that those voting to impeach the President believe that this one line that I've quoted to you from the President's grand jury testimony somehow absorbed into Article 1 his entire deposition testimony. If there's to be any regard for constitutional process, the managers cannot be allowed to rely on what the Judiciary Committee thought were false statements encompassed in a rejected Article 2 to flesh out the unconstitutionally non-specific charges of Article 1. the House's vote on Article 2 foreclosed that option for all time. Now, Article 1 next alleges that the President lied to the grand jury about the events surrounding certain statements made by Mr. Bennett during the Jones deposition. Specifically, the manager's charge that the President was silent when Mr. Bennett characterized the Lewinsky affidavit as meaning there is no sex of any kind in any manner, shape, or form with President Clinton, and that the President then gave a false explanation to the grand jury when he testified that he wasn't really paying attention when his lawyer said that. Now, as we noted earlier, Mr. Bennett argued to Judge Wright that in light of Ms. Lewinsky's affidavit denying a relationship, the Jones lawyers had no good faith basis for questioning the President about her. The President was not involved in the lengthy back and forth among the judge, the Jones lawyers, and Mr. Bennett. He said nothing. When he was asked in the grand jury about Mr. Bennett's statement, he said, "I'm not even sure I paid much attention to what Mr. Bennett was saying." Now, the managers assert that this is false because the videotape shows that the President was in fact paying attention. But a fair review of the videotape, I suggest to you, shows a President looking indeed in Mr. Bennett's direction and in the direction of the judge, but giving no sign that he was following the discussion. He didn't nod his head, he didn't make facial expressions, he did nothing to reflect the awareness of the substance of what was happening, much less what was said in Mr. Bennett's statement. Now, I don't know how large a group this would be, but any of you who's ever represented a witness or been a witness in a deposition will readily understand the President's mindset as the lawyers and the judge debated these issues. And you will understand, too, that to charge him with perjury for having testified falsely about his own state of mind with nothing more to rely on than a picture would strain credulity in any prosecutor's office and flies past the bounds of constitutional reason in this chamber. I move now to the allegations in Article 2 charging the President with obstruction of justice in the Jones lawsuit and in the grand jury investigation. I want to talk first about what's become known as the concealment of gifts theory. The allegation that the President participated in some scheme to conceal certain gifts he had given to Ms. Lewinsky centers on two events allegedly occurring on December 28, 1997. First, a conversation between the President and Ms. Lewinsky in the White House in which the two discussed the gifts, at least briefly, that he had given to Ms. Lewinsky. And B, Ms. Curry's picking up a box of gifts from Ms. Lewinsky and storing them under her bed. The managers, as was true of the majority report and the independent counsel rule before them, build their theory in this case not on any pillars of obstruction, but on shifting sandcastles of speculation. Monica Lewinsky met with the President on December 28, 1997, sometime shortly before 8 a.m. to exchange Christmas presents. According to Ms. Lewinsky, they briefly discussed the subject of gifts she had received from the President in connection with her receipt some days earlier of a subpoena in the Jones case. And this was the first and the only time, she says, in which the subject was ever discussed. And the managers quote one version of Ms. Lewinsky's description of that December 28th conversation as follows. At some point I said to him, well, you know, maybe I should put the gifts away outside my house somewhere or give them to someone, maybe Betty. And he sort of said, I think he responded, I don't know, or let me think about that, and left that topic. But the Senate should know that in fact, Ms. Lewinsky has discussed this very exchange on at least 10 different occasions